The Trump Justice Department says the redacted Mueller report is coming Thursday. Democrats pressing for the full report and underlying evidence. The news tonight, though, poses a related question. Could indicted Trump advisor Roger Stone already have part of it? Several signs point to yes, which we can report based on a flurry of developments that are super interesting happening in the Stone case. Here's what we're learning. Today, two of Mueller's prosecutors formally withdrawing from prosecuting Roger Stone, another indicator of the division of labor since Mueller finished his probe. In some areas, like redactions, he and his team still reportedly going into the DOJ to pitch in. That's why we have those early morning photos. And others, like in this Stone case, Mueller's team handing the whole thing off to D.C. prosecutors. Now, for his part, Roger Stone just filed 6 motions as part of a broad defense in this case. And here's one area where Stone's legal strategy overlaps with House Democrats. He wants the entire Mueller report. A new filing argues that as a defendant, Roger Stone has a, quote, right to review the Mueller report, and they must be allowed to review the Mueller report in its entirety because it contains the government's evidence and conclusions on matters essential to Stone's defense. Well, some might want to dismiss this as another tactic, but a defendant in Roger Stone's position has a valid claim to get at least some evidence that would be at issue in the Mueller report if it helps Stone's defense, if it's exculpatory. And this is not a hypothetical tonight, which brings me to the next piece of reporting we have for you. Stone's team already has some Mueller evidence that would typically be secret. Here's another Stone filing, citing a Mueller witness's grand jury testimony, and look at the reference, specifically citing testimony of the grand jury, transcript page 44, with exact lines listed. Why am I showing you that? Well, that's a clue that Roger Stone's team may already have some Mueller evidence by virtue of Stone being a defendant. That would be evidence that we don't think Congress has even seen yet. And within all this action, Stone is asking Judge Amy Berman Jackson to consider whether he was also selectively prosecuted for his support of Trump, and noting another Mueller witness who, quote, admitted lying to Mueller was not even charged. I could tell you tonight, Judge Jackson is responding, stating that Stone's team must specify by Thursday whether this claim of selective prosecution is asking for evidence or information other than Mueller's report, because basically she's going to have the prosecutors combine their responses if appropriate. So that's a lot, and it's something you may not have heard about because it's news. But the headlines here are Bill Barr and Jerry Nadler aren't the only players considering court clashes over the full, unredacted Mueller report. Roger Stone wants it too, and Judge Jackson may be ruling on that issue as well before this whole thing is over. Joining me now to get into this, former federal prosecutors Joyce Vance and Gene Rossi, who've been studying these filings. Good to see both of you.
Thanks for having me.
Joyce, when you look at Roger Stone's filings, whatever one thinks of him, he appears to have some evidence and makes the point that he's entitled to it.
So the interesting thing about this is that federal discovery is a pretty cut and dry issue. There's a Rule 16 of the federal rules that says what a defendant is entitled to if he or she makes a request. And then there are some additional provisions of federal law. You get, for instance, evidence that tends to prove your innocence. So Stone has filed these motions, but they really won't expand the universe of discovery he's entitled to.
And that discovery, as we know, has included what people see on the screen, which was the only reason we know what his arrest looks like is because he got that video and then leaked it to Sinclair, right? I mean, he has been, he's under a gag order now, but he has been someone who has been strategic, if you want to call it that, or assertive, if you want to call it that, in how he uses this stuff. I wonder if you can walk us through why he would appear, according to the filing, to have Mueller grand jury evidence. Everyone's been hearing Barr say, well, maybe you'll never see any of it. Stone has some of it. And for viewers who are fans of Making a Murder, they talk about this, as most lawyers and criminal procedure experts know. You do get some stuff. Take a look at their explanation of this so-called Brady material.
In a nutshell, I have to undermine confidence in his verdict. The way I undermine confidence is I find new evidence that shows that the verdict wasn't correct. I show that there were violations of his constitutional rights, that there was exculpatory evidence that was concealed by the prosecution, what we call Brady violations.
Well, what she's referring to is that you can get potentially a whole murder case overturned if they don't give you the so-called exculpatory evidence. What does it tell you that, according to this filing, they may already have some of it?
Well, I think it tells you that federal prosecutors in this case, like they are in virtually every case, were careful to comply with the requirements of the rules. And what's referenced in that clip, Brady material, is material that a defense lawyer could use to show that his client is innocent. For the obvious reasons, the rules require that that be provided to defendants before they go to trial, so they have that opportunity in front of a jury. And that's what's at stake here. It appears with this Credico testimony that Stone has either been given evidence or perhaps other defendants have shared evidence that they have with them.
Gene, your views of all this?
Well, as I told my young baby prosecutors, there are 4 parts of the federal criminal world of discovery. There's Brady, which is exculpatory information. There's Giglio, which is information about government witnesses. There's Rule 16. And then there's this thing called Jenks. It's a statement of a witness called by the government. So there's probably 2 ways at least that Mr. Stone's attorneys got this information. One, the indictment was returned in January of this year. So it's very possible that under Federal Criminal Procedure 16, there has been a sealed protective order that allows the government to provide early discovery to Mr. Stone's attorneys. And the other way is this. Before the indictment was returned, and this is what I used to do, whenever I had a target and I'm trying to negotiate a pre-indictment plea, I would get court permission to disclose grand jury information about witnesses against my target, because I did have a drug dealer one time that he wasn't going to plead guilty until he actually saw and
He saw the
held.
heat, yeah.
Yeah.
Well, what do you think, Gene, about the wider debate about this Mueller report and the idea that Stone's saying maybe even before Jerry Nadler, he should get the whole thing?
Well, Jerry Nadler absolutely should get the whole report, full Monte, unredacted. It could be it could be sealed and protected. Same with the Intelligence Committee. So it's funny that Roger Stone's interest and Nadler's interest and the House Intelligence Committee, they have a convergence of a common goal, because that report, the full report, unredacted, could have for Roger Stone information and documents that could assist him in his defense. Now, the whole report
And I don't want to
Yeah.
get too wonky, but the
I
idea,
do.
the idea that Mr. Stone may argue to the extent he made misstatements, they weren't important, they weren't material, that could relate to the larger case in the report, no?
Absolutely. So I'm not a big fan of Roger Stone, but he has defense attorneys who are doing the right thing. And that motion for the full report, he's not going to get the full report, but that report, Ari, may have information that falls into those 4 categories that I just talked about. And that's a big deal. And as Joy will tell you, appellate courts don't like violations of criminal discovery.
No, and as you and Joyce have alluded to, if the prosecutors are doing it by the book, they may have already given over basically everything that Stone's entitled to. And yet the existence of this larger unredacted report, particularly if Barr hands over something that is less than fulsome on Thursday, leaves more than one venue, including Judge Jackson's courtroom, to discuss the wider report, which is a fascinating little addition we wanted to report out tonight. And we couldn't have done it without our experts, Joyce Vance and Gene Rossi. Thanks to both of you. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.